When spouses separate, they are obligated to share information about their income and assets. Illinois courts provide several mechanisms to uncover this information: notices to produce, subpoenas, written questions called interrogatories, requests to admit facts, and financial affidavits. These tools can request practically any matter relevant to the divorce, and each request must be answered or objected to within 28 days. Despite clear rules, some people hide evidence or refuse to cooperate. Discovery is meant to be a cooperative process that helps the parties exchange information and promotes a fair settlement or trial. When one spouse owns valuable assets and is unwilling to share, enforcing discovery requests is often necessary to ensure marital assets and income are disclosed. The 201K letter before asking a judge for help. Illinois Supreme Court Rule 201K requires parties to try to resolve discovery issues informally. One spouse must write a letter explaining what documents were requested, what was received, and what is still missing. This letter proves that the parties discussed the problem, which is a necessary step before filing any motion about discovery. The rule states that a motion must include a statement that the responsible counsel personally consulted and tried to reach an accord. If the other side is already violating a court-ordered discovery schedule, the 201K letter is unnecessary. Once a complete letter has been sent, the dispute is preserved for court review. Motion to compel. If a spouse still does not provide required documents after the 201K conference, the requesting party may file a motion to compel discovery. Courts are expected to address these motions promptly and determine whether the objection has a good faith basis such as privilege or undue expense. Judges can order the documents to be produced or impose sanctions for noncompliance. Illinois Supreme Court Rule 219C grants broad authority. The court may stay proceedings, prevent the offending party from filing pleadings or presenting evidence, enter default judgment, dismiss the case, or strike portions of pleadings. These penalties are intended to coerce compliance rather than punish. Courts must balance the need for discovery with due process rights. A Chicago divorce lawyer can explain how a motion to compel works, but the basic idea is that the judge enforces the rules if parties cannot cooperate. Objections and protective orders. Parties can object to discovery requests on grounds of relevance, privilege, or other legal basis. When an objection is made, the request is paused until the judge rules. The court must rule promptly, and failure to do so can be an abuse of discretion. Most objections have some merit, and judges can enter a protective order that limits discovery to prevent unreasonable annoyance, expense, or embarrassment. Judges may weigh whether the likely burden of finding and producing documents outweighs the potential benefit in the case. However, objections must be written and signed by an attorney who certifies that the objection is grounded in fact and law and is not intended to harass or delay. If a judge finds that objections were made only to increase costs or delay, the court may require the objecting party or their attorney to pay the other side's lawyer fees. These safeguards discourage misuse of discovery. Ongoing duties and affidavits of completeness. Discovery obligations continue after initial responses are filed. Parties must seasonably supplement their responses when new documents come into their possession or control. This often applies to current pay stubs or bank statements. If a party truly does not have the requested documents, there is no obligation to produce evidence outside their possession or control. Under Illinois Supreme Court Rule 214C, a party who has produced everything in their control can file an affidavit stating that the production is complete. However, a spouse cannot avoid production by claiming the records are held by a third party when they have access to them. Courts have held that a party may be required to produce documents in the possession of third parties if the party can get them. A discovery requester is not required to pursue every possible method of obtaining documents. They can ask the other party to provide what they can access. These rules ensure that one spouse cannot simply point to a bank or employer and tell the other side to seek a subpoena. Consequences of ignoring discovery orders. If a motion to compel is ignored, a judge will hear the motion and order the party to produce documents if they have control or access to them. Refusal to comply with a court order is considered willful disregard and may lead to a finding of contempt. Courts have inherent power to enforce their orders through contempt proceedings, which could include jail until the party obeys. The order must specify what the contemptor must do to purge the contempt. In addition to possible jail, Rule 219 sanctions may be imposed, such as barring the non-compliant spouse from presenting evidence. Discovery is the engine that moves a divorce case forward. Without documents, there is no evidence or leverage. Closing discovery provides the transparency needed to resolve a divorce fairly. Illinois rules require cooperation, and courts have powerful tools to compel compliance when one spouse hides information. By understanding 201K letters, motions to compel, objections, and affidavits of completeness, spouses can protect their rights and ensure all marital assets are considered. For guidance on how to request documents and enforce discovery, contact the Chicago family law firm of Russell D. Knight at 1165 North Clark Street No. 700, Chicago, Illinois 60610 or call 773-334-6311. An experienced attorney at our law firm can explain these procedures and help you navigate your Illinois divorce.